Thank you, Mr. Deputy Chairman, for the opportunity to speak on this bill. This bill has had a bit of history. It was previously enacted for a limited period of time and had also authorized the Minister to extend its applicability by making orders for extension. And on one of those occasions, it was pointed out in this House that it had already lapsed without extending, and the Honourable Minister of Justice graciously conceded that that was the case and its applicability came to an end. Regrettably, today this bill that is before the House seeks to validate, by Clause 8, seeks to validate even acts done during that period on which this act was not in operation. The provisions that are contained in this bill had lapsed. Now, this is a very serious issue. It may be a procedural matter, but nevertheless, it has retrospective operation and is not desirable. During a particular period of time, when this law was not in operation, illegal acts that were committed by the law enforcement authorities are sought to be covered by this validation Clause 8 in this bill. Primarily, we are opposed to this bill because it seeks to extend the period of detention in a police station. Now, there is a lot of misunderstanding with regard to the 24-hour period and the 48-hour period. It must be remembered that the scheme of the Code of Criminal Procedure that we have had for over 100 years, with a brief suspension during the AJL time, the Administration of Justice Law in the 1970s, the period has been only 24 hours. And the misconception is that people think that 24 hours has been given for the conclusion of investigations, and that is wrong. If one looks at the scheme of the Code of Criminal Procedure, one will realize that the law did not expect the police to conclude their investigations within a period of 24 hours. The 24-hour limitation was only with regard to maximum permissible time in detention at a police station within the 24 hours, so that there will be a dawn, there will be a period of light during which at least the person arrested can be produced before a magistrate. Now, when he is produced, if it is a bailable offence, he is entitled to be enlarged on bail. If it is a non-bailable offence, then there is provision for detention up to 15 days, not exceeding 15 days. If the police makes an application that such a person must be detained for 15 days, the magistrate will detain that person. Now, that is the period of time that the law expects the police to conduct investigations and conclude them. It is not that first 24 hours. The first 24 hours is with regard to perhaps recording the statement of the person arrested and attendant matters like that. One does not expect the police to conclude the entirety of their investigations in 24 hours, nor in 48 hours. By extending this period of time to 48 hours, it's not expected that they can ever conclude their investigations within 48 hours. So that is why it does not make sense to extend this period to 48 hours. Now, the Minister of Justice might reply and say the requirement to produce the suspect before a magistrate within 24 hours is still maintained, and that is true. That is maintained. But what is being introduced now is that a further 24 hours or in the aggregate 48 hours, so whatever the balance time after the person is produced before the magistrate, he is permitted to be detained in a police station. That is the big difference that is being made. Already there is provision available for the investigating police officers to obtain permission from the magistrate and record statements, to interview the accused, to take him to a particular place, to continue with their investigations, although his custody is with the fiscal authorities and not with the police. Now that's a safeguard, that's a time-honored safeguard that this country has had, and there is absolutely no reason, no logical sense in providing for a further period of 24 hours in which he is kept in the police custody. This can only lead to abuse, as we have seen. Even within 24 hours, our authorities, our law reports are full of incidents where police officers have been found guilty of torture in 24 hours. Now you extend it by double the time. This will only pave the way for that kind of abuse by the police. Although there is a requirement to produce the person before the magistrate, we know how that is done. Even when a person is detained after production in 24 hours, in several instances, the Supreme Court has found that the person was in fact not produced. The police go to the magistrate's house and say the suspect is in the police vehicle. The magistrate does not see the person, and the detention order is given. This is what happens in practice, and by this the person will still remain in the police station, perhaps hung up by his 2 feet, upside down, while the police go and get an order from the magistrate to continue his detention in the police station for another 24 hours. So this is not a desirable thing. There is no real reason why this amendment ought to be brought, and that too as a temporary provisions bill applicable only for 2 years. The other reforms, or so-called reforms that are brought, are also only going to apply for 2 years, like direct indictments before the High Court. Perhaps you can cut down on time, but here the Attorney General is being empowered to make decisions, and more often than not we are going to have decisions based on political considerations rather than the strength of the case, which a magistrate at a non-summary inquiry would have been able to ascertain much more. Today the police are involved. As I said, this will lead to abuse, very serious abuse, and I want to apprise this House of a very serious abuse that is going on at present with regard to one of my colleagues, an Honourable Member of Parliament from Jaffna district, Honourable Sridharan. On the 12th of January, his office was raided without the Speaker being informed, without even the MP himself being informed, while he was participating having participated in a debate in this House and was returning. Office was raided by the said to be Terrorist Investigation Division. 25 policemen raided his office. They took many things into the office. They brought bags. They brought their own laptop computers. They put a CD into the computer and produced pornographic material, and then took photographs with his staff standing with the pornographic material on the screen of these computers. Now that material, the photographs that were taken by the Terrorist Investigation Division, are now part of a leaflet campaign against this honourable member in the area of Kilinochchi, and EPDP members are involved in distributing this material all over the place. How did the pictures that were photographs that were taken by the TID get into the hands of EPDP members for them to go and distribute this scurrilous material all over town? How did that happen? This is because the honourable member raised a very important issue in this House of abuse by the security forces, by the army, in taking over 100 young girls into their camps and abusing them. He raised it in this house, and for that he was called by the TID. And he raised a matter of privilege in this house because his speech in this house was sought to be questioned by the police. When these officers came and raided his office, this is what they said. They told the staff there, he is the MP who is saying that the women, Tamil women, are being abused. He is the one. And it is for that reason that they have brought pornographic material, they have brought condoms, and they have laid out all of that, taken photographs, arrested 2 of his associates, the staff, his secretary, and both are being detained without any production before any magistrate. We are discussing whether a person can be held in police custody for 24 hours or 48 hours, but under the Prevention of Terrorism Act, the person is detained for much longer without any production before a magistrate, and 2 of his associates are, at the time, as I speak, being unlawfully and illegally being detained in the Terrorist Investigation Division. What about 43 other youth who were arrested in Jaffna on the 30th of November, 1st and 2nd of December? They are still being held. More than 1.5 months have passed. They have not been produced before a single judge. They are said to be surrendees after giving receipts of arrest to the next of kin. After they were actually arrested, they are being described as surrendees and are being subjected to what is called rehabilitation, and we are told that they have voluntarily subjected themselves to be sent to rehabilitation. It's a joke. I want to ask the Minister of Justice this question. Ever since you became Minister of Justice, persons, Tamil political prisoners who are languishing in prisons for 10 years, 12 years, 13 years, 15 years, have written numerous letters to you. And in public, several times you have given them assurance that you will look into it. How long more do you want to look into this matter? You are bringing in a special provisions bill here to extend period of detention in a police station from 24 hours to 48 hours and other matters said to be reforms to criminal procedure. But there are over 900 people. That was disclosed by Honorable D. Gunasekara when he was Minister for Prison Reforms. He said somewhere between 600 and 900 people are there. He didn't even know the number. Close upon 1,000 Tamil political prisoners are languishing in prison, some over 10 years. You know that very well. You have got those letters to you. What are you able to do as a Minister of Justice? You give them assurance after assurance. And is it not time, Honourable Minister, that if you can't do these things, if you can't act according to your conscience and deliver, that you leave this post, that you leave it to persons who can handle this ministry, that you honourably exit and say, well, I can't anymore be party to this kind of abuse, this kind of illegality? How long more are you going to cheat the people of this country? How long more are you going to cheat the persons who have appealed to you and to whom you have given assurance after assurance? I ask you this, and I expect you to reply some of these issues that I have raised in this House today. Thank you very much.